Good morning, Council.
Mr. Justice Witt.
Good morning, Council.
Madam Justice Rajnath Lee.
Good morning, Council.
Mr. Justice Barrow.
Good morning, Council.
And Mr. Justice Jamada.
Good morning, Council.
May we have the appearances, please? Thank you.
May it please Your Honours, Devendra Kisoon in association with Mahabir Anil Nandalal, Sanjeev Datadin, Marcia Nadir Sharma, Teresa Haddad, Rishi Das, Clay Hackett, all led by Douglas Mendez, Senior Counsel, on behalf of the appellant applicants, Dr. Mohammed Irfan Ali and Dr. Bharat Jagdev.
Good morning, Your Honours. I am Timothy Afonso. I appear with Mr. Keith Scotland, Mr. Rondell Keller. We are led by Mr. John Jeremy, Senior Counsel, Mr. Roysdale Ford, Senior Counsel. We are instructed by Mr. Mayo Robertson, and together we appear for the first named intended respondent.
Your Honours, I'm Kim Kite Thomas. May it please Your Honours, and I appear on behalf of the third name intended respondent, Chairman of the Guyana Elections Commission.
Yes.
No?
May it please Your Honours.
No, we are not. If it pleases Your Honour, David Faraj, Sasha Brijmohan Singh, Adam Hussain, they are led by Mr. Fayed Hussain for the United Republican Party, and we're instructed by Ms. Candice Barrett Nahus.
Just a minute. I take it the Attorney General appears in person?
Yes, please, Your Honour. In association with Mr. Simon, Justin Simon, QC.
I see. Okay. And who appears for Mark France, Daniel Josh Kanai, and Lennox Schumann?
May it please Your Honor. May it please Your Honours, I'm Hari Ramkaran. Mr. Timothy Jonas appears with me for the 6th, 7th, and 8th respondents. Mark France, Josh Kanai, and Lennox Schumann.
Yes, thank you. Is there an appearance for Shazam Ali and Abedin Ali? Okay. Who appears for Mr. Hammond?
Should it please you, Mr. President, Your Honours, Mr. Reginald Armour, Senior Counsel, leads me, Raphael Ajodia, on behalf of Mr. Joseph Hammond.
Yes. I think we had Mr. Hossain for the United Republican Party already.
Your Honor.
Is that the case?
Yes, please, Your Honor.
Yes. Okay. Thank you very much. Those are all the appearances, I believe. Okay. Well, as you would have observed, a 7-member bench of this court presided over the conference held last Thursday, 25th June, to manage this case. At that management conference, it became evident to Justice Anderson that one of the instructing attorneys appearing before the court had been retained by him to handle on his behalf an unrelated matter. As a consequence of this disclosure, for which I thank Justice Anderson, after due consultation with my colleagues, I've reconstituted the bench to now comprise the 5 judges who are currently presiding. Mr. Mendez, are you ready to commence your submissions?
Yes, thank you very much, Your Honor. Getting right into it. Article 177 for...
Your Honours, Reginald. I don't wish to interrupt. Just a point that there are 2 objections that I will be taking when my turn comes to speak.
I'm not going to dwell on it now, but I will deal with it more substantively in my oral submissions. Thank you very much.
Yes. Yes, proceed, Mr. Mendez.
Thank you, Honors. The Articles 177 for the Constitution. I'm sorry, Honor.
I'm sorry, somebody has their mic on.
I'm asking if Mr. Khan, President, I'm asking if Mr. Khan, who appears for, I think, the Allies, is he now with us? I thought I saw him come in.
Good morning, Your Honor. May it please the court, I appear for the 9th and 10th respondents and apologize for my lateness. I had some technical difficulties this morning logging in.
I see. Okay, so Mr. Khan, you appear for Shazam Ali and Abedin Ali, is that correct?
Yes, please, Your Honor. And with me this morning is Mr. Mohammed Khan, who I believe is already on the link.
Yes. Okay, very well.
Thank you.
Yes, Mr. Mendez. Yes, Mr. Mendez.
Yes, sorry, Your Honor. Sometimes it takes a little working to get the mic to unmute. As I was saying, I was directing the court's attention to Articles 177(4) of the Constitution, which of course is at the heart of this appeal. And I was going to make the point that the exclusive jurisdiction that is invested in the Court of Appeal there is to hear and determine any question as to the validity of an election of a president, insofar as that question depends upon the qualification of any person for election or the interpretation of the Constitution. There are therefore three elements to the jurisdiction of the Court of Appeal that is stated there. The first is the identification of a question to be heard and determined. And so therefore what the court will have to do is to identify what question the court is being called upon to hear and determine. The second element is that that question must be as to the validity of an election of a president. That's the second aspect of it. And the third aspect is that the question must depend upon either the qualification of any person for election or the interpretation of the Constitution. So those are the three aspects of 177(4) that I wish to address you on this morning. Now, as to the first, that is to say the identification of the question, because the question that the court must identify in order to hear and determine it concerns the validity of an election, then one would ordinarily expect that the applicant under 177(4) would be pointing to something that somebody has done wrong that may give rise to the invalidity of the election. And of course, in order to determine exactly what it is that the applicant is saying went wrong, then you'd have to look to the pleadings, to the notice of motion, and to any other accompanying documents that would identify exactly what the question is that the applicant is bringing before the court for hearing and determination. Now, when you look at the first respondents, Ms. David's case, if I may refer to her as Ms. David from now on, you of course look at the notice of motion, and in the notice of motion itself, on the face of it, which you will find at page 89 of the record, you will see that she says that the grounds for this application are set out in the affidavit in support of the motion. So she directs us to the affidavit, and I will ask you to look at that very, very briefly because of the limitations of time. But when you look at the relief that she sought, you will see from reliefs A, C, D, E, and F, which is at page 90 and 91 of the record, that there is a common theme in those reliefs that she is seeking. And that common theme is that the Guyana Elections Commission was supposed to determine a final credible count, or the credibility of the result of the general election, in accordance with the Order 60 of 2020, but they did not do so. That from the relief you gather that that is the kernel of the complaint that is being made. In relief B, mention is made of an order for the interpretation of the words "more votes are cast." But if you are to try to find out exactly what it is that the applicant was saying went wrong, and you look at the relief, the only thing that they're saying that went wrong that might give rise to invalidity is the failure of GCOM to determine a final credible count, as they say is required by Order 60 of 2020. Now, you will notice as well from the relief, before I take you away from that document, that there is no relief sought asking the court to invalidate an election. There's nothing sought there at all. They are simply seeking to have certain questions determined, as it appears, quite separate and apart from any election being declared to be invalid. Again, when you look at the affidavit of Ms. David, particularly from pages 97 onwards, you will see that what she recites there is that there was a recount. I won't take you before then, for again, having regard to the shortage of time. There's a recount that is ordered by Order 60 of 2020. The recount was held. There were certain results that became public, PPP1. Then, there were, during the course of the recount, a number of complaints being made by Mr. Harmon, and he wrote to the commission about that, pointing to a number of what he said were irregularities and discrepancies. And the GCOM made a determination that, as far as it was concerned, it was not, it was out with its powers to determine whether any of the votes were invalid as a consequence of these irregularities, and more particularly, it made a determination that it did not have to, or was not required to, or it was out of its powers to determine whether the election was credible. Now, that is what Ms. David says in her affidavits, and that is what she is complaining about, that they did not make a final determination as to a credible count. And when you look at the submissions filed on behalf of the claimants immediately after, that is to say within the next day, I think the claim was filed on the 18th of June, and on the 19th of June, there were submissions made on behalf of Ms. David in writing, and you'll see that beginning at page 219 going on. You will see once again that there were complaints made about the commission failing to comply with what they say was the commission's duty of determining a final credible count. And once again, they made references to the order, they made references to how the order should be determined, and they say if the order is interpreted properly, then GCOM would be required to determine a final credible count. So that was the kernel of their complaint, and I don't think that is disputed. The connection that they made between that complaint and Article 177 was that they said that, well, 177(2)(b) must be interpreted to mean more valid votes cast, and presumably they are saying that you can't have more valid votes cast unless GCOM determines a final credible count in accordance with the order. But that is how they seek to transparently connect what the real complaint was, which is the failure of GCOM to determine a final credible count, with Article 177. Now, before I go further to the second point, that is to say whether the complaint raised a question as to the validity of an election of a president. If I can just detain you very quickly by a reference to the code, as it were, under the Constitution for the election of the president. And that begins with Article 91 of the Constitution, which very briefly says that the president shall be elected by the people in the manner prescribed by Article 177. So it directs you to 177, and that is the only place where you will find the way in which the president is elected. So that takes you to 177.1, and 177.1 simply provides in the first instance that the list of candidates for the election, and that is something that is determined in other parts of the Constitution, must designate one person as a presidential candidate. So you must have the name of somebody who is designated a presidential candidate. And then 177.1 says that an elector voting at such election in favor of a list shall be deemed to be also voting in favor of the presidential candidate. So the vote that you cast is the vote for the list, but Section 177.1 deems that vote to be a vote for the president. 177.2 then tells you, gives you guidance as to how you determine who has won the election. And 177.2a says that if there's only one presidential candidate, well, that is the person that wins. But if there are two or more presidential candidates, then the person who wins is the person who is on the list if more votes are cast in favor of the list on which the person is designated as the presidential candidate. But then it goes on to say that that candidate shall be deemed to be elected as president and shall be so declared by the chairman of the Elections Commission, acting only in accordance with the advice of the chief elections officer, after such advice has been tendered to the Elections Commission at a duly summoned meeting. So when there are two or more presidential candidates, the winner is the one who is on the list that gets the most votes cast. Now, Article 177 does not tell you or does not provide a procedure as to how you determine which list got the most votes. It doesn't tell you that. Article 177.5 makes provision for Parliament, making provision for the conduct of the elections, but no such provision has been made. And as we've pointed out in our submissions, provisions have been made for determining how many votes have been cast for each list of candidates, and that's in the Representation of the People Act. And we have pointed out the transition from the 1970 Constitution to the 1980 Constitution, pointing out that the order, that's Order 50 of 1980 that was made, continued the Representation of the People Act in force under the 1980 Constitution, but specifically said that it was to be in relation to the election to the National Assembly. So we know that the RPA governs how you determine how many votes were cast for the list of candidates. So when you read in 177.2b, if more votes are cast in favor of the list, there's nothing in 177 to tell you how you determine that. So it's plain that you will have to look somewhere else to figure out how you determine how much votes were cast for each list. But the procedure for the election of the president is as indicated in 177.2. That is to say, you have to have a meeting of the Elections Commission. At that meeting, the chief elections officer must present advice, and the chairman of the Elections Commission must act in accordance with that advice and declare the president. That is the procedure. That is the only procedure that is provided for under 177. But those are the formalities of the election. You have to have a procedure for determining which list got more votes, but that is the procedure under 177, and that alone. So it is not until that happens, until you have the meeting of the commission, the CEO presents his advice, and the chairman makes that declaration, that you know who the president is. And of course, you have Article 177.6 providing for the modalities for making that declaration. And 177.6 says, subject to the provisions of paragraph 4, an instrument which is executed under the hand of the chairman states that the person in the instrument is declared elected shall be conclusive evidence that the person so named was so elected. So that is how you know who is elected. You have that instrument under the hand of the chairman, and that is when the election of the president is known and is complete. So it is in that context that we get to the second part of the definition of 177.4. That is to say that in order to invoke the jurisdiction of the Court of Appeal, you must be raising a question as to the validity of an election of a president. That is what you must be raising. Now, ordinarily, again, if you are raising before the Court of Appeal a question as to the validity of an election of a president, then the process should end with a determination either that the election is valid or that the election is invalid. That's the normal end of the process. But of course, in order for that to be the end of the process, you first have to have an election. So we are saying, we respectfully submit, when you interpret those words, the first impression that you get is that you have to be challenging the election of someone. Somebody's election is under challenge. Somebody's election is being said to be invalid. And therefore, you will be interested to identify whose election. Because if you are making the application saying that somebody's election is affected, you first of all have to ensure that that person is before the court in order to invalidate that person's election. It is interesting, of course, that Ms. David commenced these proceedings and did not name any presidential candidate at all. Didn't name any president. Mr. Ali, who is the presidential candidate designate on the list of members for the PPP, he had to join, as did Mr. Jagdeo, who is the representative on that list. So it's quite telling that Ms. David didn't name anyone whose election might have been in jeopardy. And indeed, at the time that she filed a notice of motion, the only president in existence was President Granger. And of course, nobody was saying that his election, which would have occurred 5 years ago, was under challenge. We respectfully submit that the jurisdiction under 177.4 can only be invoked after an election has occurred. Now, we say so because obviously Article 177.4 has to be interpreted against the backdrop of election jurisprudence. And prior to 1970, when the precursor to Article 177.4 was first enacted in relation to the president, you had learning in Guyana itself, in the case of Petrie, which established a policy, a general policy following the Supreme Court of India in the Punaswamy case, which basically said that it is important that disputes concerning elections are not taken before the election is over, because you might delay it, you might cause confusion, you might cause disruption. It is important as a matter of policy that if you have a complaint or there's a dispute over an election, that dispute be taken after the election by way of the procedures that are provided therefore. And you will see that in Punaswamy, if you look at page 1532, that is in the appellant's bundle, you will see that this is what the Supreme Court said. It said, having regard to the important functions which the legislatures have to perform in democratic countries, it has always been recognized to be a matter of first importance that elections should be concluded as early as possible according to time schedule, and all controversial matters and all disputes arising out of elections should be postponed till after the elections are over, so that the election proceedings may not be unduly retarded or protracted. In conformity with this principle, the scheme of the election law in this country, as well as in England, is that no significance should be attached to anything which does not affect the election. And if any irregularities are committed while it is in progress, and they belong to the category of class which, under the law which elections are governed, would have the effect of vitiating the election, enable the person affected to call it in question, they should be brought up before special tribunals by way of an election petition and not made the subject of a dispute before any court while the election is in progress. Now, that is a decision of the Supreme Court of India made in 1952. That was followed in Petrie, and you'll see at page 1362 of the record. And that's the decision of the Chief Justice Bollers in Guyana. And you'll see at page 1362 that he followed Punaswamy and basically indicate in that particular case a constitutional challenge had been made to the elections before the elections had been concluded. And he basically said that that issue had to be taken after the election for this, citing the same policy considerations. And this court, Your Honors, in the Ram case decided recently, at page 1324, This is what this court said towards the bottom of that page. You said that there are two important policy reasons for the Constitution denying the court an inherent jurisdiction in the realm and allowing that jurisdiction to be specifically conditioned by rules. And the second one was, as Boller CJ stressed in Petrie, it is in the public's interest that the validity of an election and hence membership of Parliament should be quickly determined according to strict rules and procedures that are predetermined by Parliament. So again, this court has adopted and enforced that policy. That is to say, you have to determine elections as quickly as possible. And the general principle is that you determine it after the election has been determined, so that the country can settle down, you have a government in place, and then the due process of law takes its course thereafter. Now, as I'm submitting, Your Honors, the Section 177.4 has to be interpreted against that backdrop. That was the learning before 177, the precursor to 177.4 was brought into being in 1970, and of course it's continued in identical form thereafter. Now, it's clear that you can make a challenge under 177.4 after the election. That is clear because in 177.6, as I've just read to you, it says that subject to the provisions of paragraph 4, an instrument that declares the president is conclusive evidence of the election, and then it says it shall not be inquired into in any court. It says that. The intention is to create some finality, but it says subject to paragraph 4. So obviously, and paragraph 4 takes you back to the jurisdiction of the Court of Appeal. So 177.6 is making clear that even after the president is declared, you can invoke the jurisdiction of the Court of Appeal under 177.4. What the first respondent, Ms. David, is saying in this case is that you can invoke it before any time. There's no indication of any time limit. But I would respectfully submit in any event, Your Honor, that if we drill down into that proposition, we'd realize that that there are a number of anomalies. Let us say, for example, that the question that the court was being asked to determine had to do with the qualifications of a candidate. Now, if you could take if you could move the court at any time prior to the election being concluded, then you can presumably move the court as to the qualifications of a candidate immediately after the person is nominated and his name is put on the list. So if you move the court under Article 177.4 to raise that question, then the question that you will be putting before the court is not as to the validity of the election of that person. You will be putting before the court a question concerning the qualifications of that person to be elected. Or you'll be putting before the court the question of the validity of the person's nomination. You could not be putting before the court any question as to the person's election because, of course, no one knows exactly what is going to happen. And of course, that state of affairs, that is to say, challenging the question whether the person is qualified to be elected, would be the question that you would ask, or you would be asking the court right up until the person is in fact elected. The question is not transformed from a question as to whether the person is qualified to be elected to a question as to the validity of that person's election until they are in fact elected. So certainly in relation to qualifications, the question that you'll be putting before the court at any point in time before the election will be as to whether the person is qualified to be elected. And that is not a question as to the validity of the election itself. That we respectfully submit demonstrates that the intention behind the 177.4, when it says that you raise a question as to the validity of an election of a president, is to raise that question after the election has occurred. That, of course, did not happen in this case. And we respectfully say the Court of Appeal, as a consequence, ought not to have accepted jurisdiction to determine the question that was before the court. Now, if I can come on to the third question that I've raised, and again, I'm very conscious of time. It's now 23 minutes have gone by already. Your Honors, I see Justice Jamada smiling. Your Honors, the third point is that the Court of Appeal only has jurisdiction in relation to a question as to validity that depends upon, and that's the important phrase, the question as to validity must depend upon one of two things, qualifications or the interpretation of the Constitution. If the question as to validity that has been raised does not depend upon either of those two things, we respectfully submit that the Court of Appeal does not have jurisdiction. Now, the first thing I would like to submit is that in interpreting those provisions and thereby determining what the exclusive jurisdiction of the Court of Appeal is, we must also bear in mind other provisions of the Constitution that vest exclusive jurisdiction in other courts. And of course, in this particular instance, we must bear in mind that Article 163 vests exclusive jurisdiction in the High Court under a separate code. And the jurisdiction that is vested in the High Court would be a jurisdiction, and I don't think anyone disputes this, to determine the validity of an election. That election is the election to the National Assembly, and therefore what immediately falls within the purview of the High Court under its exclusive jurisdiction is the jurisdiction to determine the validity of the votes cast for the lists. That would be the first thing that falls under its jurisdiction, because when you're challenging the election to the National Assembly and you're saying that it's invalid for one reason or the other, certainly one of the main reasons would be the validity of the votes cast for the list. And as I pointed out earlier, the procedure for determining the votes cast on the list for each list is set out in the Representation of the People's Act. It will also be governed by any orders that the Commission is moved to make under its special powers under Section 22 of the Election Laws Amendment Act. So the validity of the votes would be affected by the RPA and by any orders that it makes. So on the face of it, the exclusive jurisdiction of the High Court would be to resolve any disputes that have arisen concerning breaches of the Representation of the People Act or breaches of any orders that GCOM may have made in relation to the tallying of votes or the conduct of the elections generally. That would fall within the jurisdiction of the High Court. So we have to be careful then in carving out exactly what the exclusive jurisdiction of the Court of Appeal is, to bear in mind that the High Court also has an exclusive jurisdiction. And you can't have, both courts can't have exclusive jurisdiction over the same thing. Now, it's important again to appreciate when you come back to the jurisdiction of the Court of Appeal that its jurisdiction is limited to questions as to validity which depend upon an interpretation of the Constitution. So that must mean that the complainant who comes before the Court of Appeal is saying that there is some provision of the Constitution that has been breached that potentially results in invalidity. And this is why I'm coming before you to ask you to make the determination that the election is invalid. A constitutional provision has been breached and you are now required to interpret the provision of the Constitution. It has to be within that realm. So that it follows as well that if the question of validity is really depending upon the interpretation of another law, not the Constitution, if, for example, it depends upon the interpretation of the Representation of the People Act, then that is not for the jurisdiction of the Court of Appeal. And likewise, if the question as to validity depends upon the construction or the enforcement or the alleged breach of an order that GCOM was moved to make under its special powers under Section 22 of the Election Laws Amendment Act, then that would be again for the High Court. It would not fall within the exclusive jurisdiction of the Court of Appeal on the face of it. Now, that is precisely what happened in this case. Now, what the Court of Appeal was asked to do primarily was to make that determination. When GCOM said that it does not have the jurisdiction to determine the credibility of the count, was it correct? Look, the argument before the Court of Appeal was, look at the order, interpret the order, determine whether under the order GCOM was required to determine the credibility of the vote and make an order accordingly. Now, that is exactly what the Court of Appeal did. It didn't grant any of the relief sought, as it called, recursive orders, but nevertheless, it made a determination as to what GCOM's order meant and as to what GCOM's obligations and functions were under that order. But that, on the face of it, had nothing to do with...
Mr. Mendez, may I interrupt? Is it correct that GCOM, in saying it did not have the jurisdiction, also indicated...
Sorry, Your Honor, your voice broke up.
Is it correct that GCOM, in saying that it did not have jurisdiction, also indicated who it thought had that jurisdiction?
Precisely so, Your Honors. They said that because the question of credibility at that stage was being raised in relation to the irregularities that Mr. Harman had brought its attention. And it's important to, if I had more time, I would take you through the list of those irregularities. But just to give an example, what he was saying was that there were certain documents that were not found in the ballot boxes when the ballot boxes were opened. And also he was saying that there were persons who were actually deceased who were being recorded as voting, and also persons who were not in the country who were being recorded as voting. So in other words, he was saying there was impersonation of voters taking place. And GCOM says, well, we can't determine those questions. Those are questions that have to be determined by the High Court. And that is right, because that is a normal complaint that you will find being made all over the world before election courts, that there are persons who voted that either were not on the list, or that were on the list that were dead, or were on the list but actually were not in the country at all, or there are persons who voted twice. A number of these things happen all of the time, and that is what the election court is there to resolve. So when the GCOM was saying we don't have the jurisdiction to pronounce upon these irregularities that you have brought before us, it was saying that is for the High Court, not for us. And of course it can't do it, because it doesn't have the procedures to be able to take the evidence that is necessary in order to determine whether somebody in fact impersonated somebody else. So that is what they said. So it is not so much an abdication of powers as it's saying we don't have that power. Now, they may be right or wrong, but that is a question that anyone complaining about what GCOM did can take before the High Court and say the election was invalid because GCOM ought to have made these determinations and they abdicated their responsibility to do. That's the High Court's exclusive jurisdiction.
May I interrupt you with one short question? In terms of executive, legislature, judiciary, GCOM would fall more into which arm of state?
Your Honor, Mr. Justice Jamada, we're having a difficulty hearing you. Your voice is being interrupted every now and then. But I think you're asking whether they'd fall within...
Your Honor, John Jeremy, I am not hearing Your Honor at all. I don't know if the difficulty that Mr. Mendez is experiencing is as acute as mine. I know that Your Honor is speaking, but that's about it. I'm not hearing the question.
Your Honor, I heard enough to understand that what you're asking is whether GCOM fell within the executive, the legislature, or the judiciary. In other words, into which arm of the state GCOM fell. And my answer to that is that it falls within the executive. It is obviously not part of the judiciary because none of them are appointed as judges. None of them have the qualification for judges, as a matter of fact, or need to have the qualification for judges, I should say. And indeed, 6 of them are political appointees who don't have to have any judicial qualifications at all. And that has been examined by this court in the Zulfikar Mustafa case. So it falls within the executive. So plainly, they do not have judicial powers. And plainly, it would have been a violation of the separation of powers doctrine if they had assumed to themselves the power to make the determinations that they were being asked to make. So to a certain extent, if the question had arisen, obviously they were right to say that we do not have the power to exercise, to do what we were being asked to do. And if it is that the Court of Appeal did have the jurisdiction to ask the questions at all, we would say that the Court of Appeal was wrong in determining that GCOM was under an obligation to make these determinations on irregularities, because that would violate the separation of powers doctrine. And that would be another reason why the Court of Appeal would step outside of its jurisdiction, because it made a determination that violated the separation of powers doctrine in requiring GCOM to make a determination that is reserved for the High Court itself.
Mr. Mendes.
Mendes, you have very limited time left.
Yes.
And you have not at all dealt with as yet whether the court has jurisdiction, notwithstanding all the points that you have made, whether the finality clause precludes this court from exercising any jurisdiction over what was determined by the Court of Appeal.
Yes, Your Honor.
And Mr. Mendes, when you do tackle that, kindly look, I know you will, but just a brief reminder, the matters that were raised by some of your friends concerning the impact of the clause, the article in the agreement establishing the court and in the CCJ Act. If you could put those together, I'd be very happy. Thank you.
Yes. Your Honor, the article in the agreement, I think it is, I don't remember the number off, and I'm terribly sorry, but the clause in the CCJ Act that is identical to that clause in the agreement is section 4.3 of the Act. What it basically says is that the Court of Appeal, the CCJ, does not have jurisdiction. It says nothing in this Act shall confer jurisdiction on the court to hear matters in relation to any decision of the Court of Appeal, which at the time of entry into the force of this Act was declared to be final by law. Now, we have, of course, in our reply to my learned friend said that clearly this court does not have jurisdiction to hear appeals from decisions that are declared to be final. But that doesn't answer the question. The question is, what decisions are declared to be final under the law of Guyana? That is the question that we have to ask. And the only way that we answer that question is by looking at Article 177.4 to see what questions, to see what decisions are declared to be final. And under 177.4, it says that decisions made under this article are declared to be final. So we have first to determine whether the decision which the Court of Appeal made was a decision under Article 177.4. If it is a decision made under 177.4, then this court has no jurisdiction. But what we have submitted, and what I have been at pains to submit this morning, is that the decision that the court made, and indeed the proceedings themselves, were asking the court to make decisions that did not fall under 177.4. And as I've just indicated, the last submission that I was making, the jurisdiction that the Court of Appeal has under 177.4 is to determine questions as to validity that depend upon the interpretation of the Constitution. So if it determined a question as to invalidity, which depended upon the interpretation of something else other than the Constitution, then that is not a decision under 177.4, and therefore it is not a decision that is caught by the finality clause in 177.4. If that is so, if the decision is not caught by 177.4, it is therefore not the subject of the exclusion of your jurisdiction under section 4.3. Your jurisdiction is not excluded, and therefore we have to look to the other provisions of the CCJ Act and the agreement that vest jurisdiction in the CCJ. And when we look at those provisions, we see that you have jurisdiction in relation to questions concerning interpretation of the Constitution. You have jurisdiction on special leave in relation to all civil matters. It doesn't say what type of civil matters. As far as special leave is concerned, you have jurisdiction in all civil matters. And of course, you also have jurisdiction in relation to matters that are of great general or public importance with the leave of the Court of Appeal. So this case, we respectfully submit, falls within those categories where you have jurisdiction, because in order to resolve the question, what is the jurisdiction of the Court of Appeal under 177.4, you have to interpret the Constitution, first and foremost. You have to, and in the context of the case, you have to determine, was the question decided by the Court of Appeal one which depended upon the interpretation of the Constitution? I respectfully, if I may, adopt the learned submissions of my friend Mr. Hussain when he makes a very important point that this is the apex court. This is the apex court that determines what the Constitution provides. And unless you are expressly prohibited from making determinations as to what the Constitution provides, then your jurisdiction is there under the later parts of the CCJ Act, particularly Section 8. And respectfully, you must exercise that jurisdiction. My learned friend, Mr. Armour, referred to the ICJ decision, which said, yes, you must not exercise jurisdiction in relation to matters that have been excluded, but otherwise, you must exercise your jurisdiction to the fullest extent. And that is very important. If you don't do that, then you would be, with respect, violating the Constitution of Guyana by not yourself taking on a jurisdiction that is vested in you. And certainly would respectfully submit that you must have jurisdiction to determine the jurisdiction of the Court of Appeal when it is exercising a limited jurisdiction. And under 177.4, that jurisdiction is very closely defined. It's not a jurisdiction at large. It's a jurisdiction that is clearly defined, as I've indicated. It must be a question as to validity of an election, and that question must depend upon two things. If it depends upon anything else, 177.4 simply does not apply. Now, Your Honors, if I may very quickly, related to the point that I was making before, which is that we have to ensure that the exclusive jurisdiction of the High Court is not infringed upon, is the point that in any event, the Court of Appeal acted in violation of Section 140 of the Representation of the People Act. And I'm very conscious of time. It's now 42 minutes of my submission. And if I can just take 1 or 2 minutes to make this point. The point was not taken in the court below. But again, this court has said, and I've cited the decision in the Sheffet case where you said, if what you are raising is a strict point of law, not dependent upon any points of, any findings of fact, then this court in its discretion will allow the point to be raised. But in any event, there's this important consideration. In the Ulita Moore case, the Court of Appeal had said, and if I may quote from it, it's in my learned friend, Mr. Jeremy's bundle, and you will see at page 3139 that the Court of Appeal said at para 108, on the main issue in this appeal, we have found that the jurisdiction of the High Court can be exercised to grant relief during the election process in spite of Section 141 of the Act. That jurisdiction can be exercised where the court is satisfied that GCOM has acted or is about to act in excess of its constitutional and or statutory powers. Section 140 is, however, effective in excluding the court's intervention in relation to functions which fall within the responsibilities of GCOM in its management of the electoral process. Now, The point is, Your Honors, if we had raised 140 before the court would have said, well, we have already determined that issue. Now, exactly how we make a distinction between the exercise of statutory powers and the exercise of its management of the election process, I'm not entirely clear, because the GCOM in the management of the election process will be exercising statutory powers. It doesn't have any inherent powers. So it would have been pointless raising the Section 140 point before the Court of Appeal, because they had already made that determination. For the reasons that we have given in our respectful submissions, the Ulita Moore case is wrong on the question of the ambit of 140. The authorities that we have cited indicate that the anisminic narrow interpretation of ouster clauses does not apply where the ouster clause that we are talking about, and I'm saying ouster clause in inverted commas because it's not really an ouster clause, but where the clause that we are talking about says that you raise the question in another forum, where that is the provision that you're talking about, it is not a question of ousting the jurisdiction of the court at all. It is a question of directing the question to be answered in another forum. And therefore, we say in any event that the Ulita Moore decision is wrong, and this is the only place that we can come to say that the Ulita Moore decision on the question of the ambit of Section 140 was wrong. So we ask you to hear us on the, to allow us to raise the question of Section 140. The point being that the 140 point reinforces the position that the exclusive jurisdiction of the Court of Appeal has to be interpreted in such a way as not to encroach upon the exclusive jurisdiction of the High Court. Section 140 is making it very clear that questions concerning the performance of GCOM's functions has to be taken to the High Court. And that is exactly what the Court of Appeal was doing, commenting upon the performance of GCOM's functions in relation to the order that it had made. So for all of these reasons, respectfully submit.
Mr. Mendes, before you close, what exactly is the relief or the reliefs which your client is seeking?
Well, first of all, Your Honors, we ask that the appeal be allowed, that the motion be dismissed, because the Court of Appeal never had jurisdiction in the first instance to make any of its pronouncements. And that ought to be made clear, that none of its pronouncements can stand because it had no jurisdiction to make them, to enter into the inquiry in the first place. The point, however, Your Honor, is that since the court made its decision, and very, very soon thereafter, the Chief Elections Officer, on the basis of the Court of Appeal's determination made without jurisdiction, then submitted a report to GCOM, which he says is the Section 96 report, in which he invalidated 115,000 votes. We ask you, therefore, this is before the court, we have seen the letter that he has written to GCOM invalidating 115,000 votes, and he said that he did that because of the guidance be given by the Court of Appeal. So we ask you to make consequential orders to require him to withdraw that report, and then everything else would take its course thereafter. GCOM will require whatever report it needs from him, and it will then declare the election in accordance with the report that is produced, presumably in accordance with the recount.
Mr. President, I would like to ask one question, if you would allow me.
Sure.
There are so many learned counsel in this case that maybe the simple and obvious things might disappear. But what is so important to say that you can only become president if you get more valid votes? I always thought that was logical. You cannot become president with invalid votes. At least that's what I think. The problem is, what do we mean by valid votes? I also think that there are two elections, president and members of the National Assembly, but it is like a Siamese twin. One cannot go without the other. So actually, when you look at the counting of votes in Section 96 of the Representation of the People Act, speaks about valid votes. But that has a special context. There is a system. We know exactly, reading the Act, what is meant by valid votes. Now, if you give a different meaning to the word valid in the Constitution, in Article 177(2), then you would change the Representation of the People Act in the same swoop, because, and as I understand, the chief election officer came up with a very different tabulation, which is not in accordance with the Representation of the People Act. So once you change the meaning of a word, and I think we all agree that that should be valid votes, but once you change that meaning, then it has repercussions on other legislation. And it would seem to me that that would not be within the jurisdiction of the Court of Appeal. And it would be very dangerous if that could be done in this way. Seems to me.
Your Honor, first of all, I agree with you that I don't think anyone would suggest, and certainly no one was suggesting, that the reference to more votes cast in 177(2) meant more invalid votes cast. And in fact, we're not aware of any dispute as to exactly whether it was valid votes that you had to count or not. And if all the applicant came to the court for a determination was as to whether it's valid votes in 177(2) or not, then probably nobody would be concerned. The question of jurisdiction would still arise, and it still arises, even though all the court did was to insert the word valid, even if that is all that it did. But the fact is that it went further, and it said valid in accordance with Order 60 of 2020. And therefore, it in effect amended the Constitution by saying that the order that GCOM made now amends 177(2). And in fact, that is what Ms. David was asking the court to do from the word go, to insert in the clause the words valid and credible, getting its inspiration from Order 60 Rule of 2020. I would respectfully submit that, I mean, I'm fairly certain that if all Ms. David was concerned about is whether the word valid should be put there, she wouldn't have come to court at all. The reason why she came to court was to get a determination by the Court of Appeal as to what GCOM was obliged to do. And therefore, she was asking the Court of Appeal to answer a question that the Court of Appeal was not authorized to answer under 177(4). It could answer that question, but only after the High Court gave its answer on an election petition, and then there was an appeal to the Court of Appeal. It could answer the question then. But in those circumstances, then there would be an appeal to the CCJ, for the CCJ to give its final answer, because the appeals in election petitions are not final in Guyana. So by coming directly to the Court of Appeal, they were seeking to bypass the system that was already in place. And respectfully, that is not permitted under the Constitution.
Mr. Mendes, your time is up.
Thank you very much,
for your submissions. Mr. Jeremy, are you ready?
Yes, Your Honor. Your Honor, at the outset, I want to indicate to Your Honors that I will be following my own batting order, so that Mr. Mendes went first, but I'm not going to allow him to define the conditions of my response. The points which he raises are addressed in fact in what I propose to see. I just like at the outset to ask that I be given the time indulgences which he was. My Lord, the full bench asked to be addressed on 4 questions, none of which dealt in any way with the merits of the appeal. Mr. Mendez went to great lengths on a query as to what reliefs he sought to ask your lordships to grant broad and sweeping reliefs which went to the merits of the appeal. Those 4 questions, your honors, dealt with the application that is before you this morning for special leave. Now, if I carry your lordship to those questions, in the course of answering those questions, I will answer or attempt to answer certain of the points that he has made, the more germane ones at any rate. The first of those questions, just to remind your lordship and to have it before us in context, was whether the Court of Appeal had jurisdiction to entertain the motion filed by Eslyn David. And my answer to that, your honors, is that the Court of Appeal was exercising without doubt its powers under Section 177(4) of the Constitution of Guyana. Now, I'd like to read that article, and it provides as follows. The Court of Appeal shall have exclusive jurisdiction to hear and determine any question as to the validity of an election of a president. More on that in a while. I'm not going to address that as Mr. Mendez did at the outset, but more on that in a while. Insofar, that is, as the validity of the election of a president, as that question depends upon the qualification of any person for election or the interpretation of the Constitution. And then there's the finality provision, and any decision of the court under this paragraph shall be final. My Lord, there is authority on what that section means, and it's to be found in the case of Re UC Guyana, which is in the electronic bundle at 1393. My lords, and I carry you to the end of that page. Do you have the page, the authority on the page?
Yes, proceed.
Now, at the end of 1393, the Guyanese Court of Appeal, acting as the final court in Guyana in 1980, says this: the issues that can be properly dealt with are the qualification of the president, that is the qualification of the president, or the interpretation of the Constitution. Lord, those words do not require any interpretation. Those words in the judgment, they are words of the final Court of Appeal in Guyana in 1980. So that the case law tells us how the section is to be construed. And with respect to Mr. Mendez's point on the trigger being the election of a president, well, my Lord, there is authority as well, which we have cited. It's at page 3001 of the electronic bundle. And I'm reading. Do you have it? Do you have it, Your Honor?
You go ahead. Yes.
And that's the case of Narayan Bashka. And this is in respect of what is meant by the word election. And the court says towards the bottom of 3004, 3001, sorry, that word has by long usage in connection with the process of selection of proper representatives in democratic institutions acquired both a wide and a narrow meaning. In the narrow sense, it is used to mean the final selection of a candidate, which may embrace the result of the poll. When there's a polling or a particular candidate being returned unopposed, when there is no poll. In the wide sense, the word is used to connote the entire process, culminating in a candidate being declared elected. But Lord, Your Honors, I rely on that case, on the meaning that it places on the expression election to include a process, and I say that the court in Riusi Quayana tells us what when the section can be invoked, and the court in the Narayan case tells us what is an election. I don't need Mr. Mendez to tell me what an election is.
Mr. Jeremy, do you know of, or have you been able to cite any case where a question as to the validity of the election of some governmental official was heard and determined by the courts before the official was elected?
My Lord, I have not been able to find such a case. Okay,
if your side prevails, this would be precedental. This would be the first time in the Commonwealth, so far as your researches have gone, where a question as to the validity of the election of some governmental official was heard and determined by the courts before the official was actually elected.
Yes, my Lord, in many respects, and in certain respects cited by my learned friend, Mr. Mendez, it would also be precedental.
Yeah. Mr. Jeremy, thank you much for bringing to our attention, I believe it's the Ryan Carey case, the one that you just cited. It's interesting that in that matter, the petitions were seen as premature because it said that that power that was in the Supreme Court to inquire into and decide the doubts and disputes arising out of and in connection with the election of the president can be exercised only after a particular candidate has been declared elected. So I appreciate what it says about how you have made your submission, how you've couched it with respect to what is an election, but still the result was not in favor of the petitioners.
Thank you, Your Honor, but the case is distinguishable because if you look at 3003, in India, there were other provisions of the Constitution and rules which provided that the challenge was to be brought after. But the case is authority for the proposition as to what is meant by an election. There are no such rules in Guyana. Now,
Just point me to the very rule that you're speaking about in India, Mr. Jeremy.
Yes, yes. Okay, so it is at page 3002 of the report. If you just turn the page towards the bottom of the page, it's the paragraph before 145. 9 lines from the bottom. 9 lines from the bottom. In exercise of powers conferred on it by Act Article 71(3), Parliament has enacted the Presidential and Vice Presidential Election Act, 1952. And the purpose of that act is to regulate certain matters relating to or connected with elections to the office of President and Vice President of India. A glance through the provisions of the act will indicate that in the view of the Parliament, time was of the essence for the jurisdiction to inquire into and decide doubts and disputes arising out of or in connection with the presidential election. Under Article 14 of the Act, which corresponds to 18, no election shall be called in question by an election petition presented by the court. In Section 18 lays down the grounds and then the grounds are then set out in 18. Grounds for declaring the election of a returned candidate to be void if, in the opinion of the Supreme Court, A, the offense of bribery result of the election by reason that the offense, the improper reception of a refusal in non-compliance of the provisions of the Constitution of this act or of any rules, that the nomination of the candidate has been wrongly rejected, and so on.
Yes, continue.
Thank you, Your Honors. Your Honors, I deal with that point. I elaborate on that point at paragraphs 22 and 23 of my written submissions. Now, if you take, so what I've done is to seek to focus on the Constitution itself and what it says. And I have attempted to interpret what it says, not by giving my view of what the construction ought to be, but by pointing your honors to authority, Guyanese authority and Indian authority. Now, if we take Mr. Mendez's construct without authority, on the face of it, there are certain absurdities which would arise. One is, and I can refer your lordships in the interest of time to paragraphs 25 and 26 of my submission. That is page 2959 of the electronic bundle. And in particular, at paragraph 26, I say that his argument, taken to its logical conclusion, will cripple the entire title and will also mean that all declarations of the elections of presidents since 1980 have been unconstitutional, because he argues that the absence of rules cripples the provisions in the section. Now, if you look with me at the motion, that is the motion by which we move the Court of Appeal. And Your Honors, Mr. Mendez carried you through an entire list of the relief which we sought before the Court of Appeal. and attempted even there to interpret what we were asking the Court of Appeal to do. But I ask your lordships to look at the reliefs themselves. And at B, that is at page 90 of the electronic bundle, we ask the Court of Appeal for an order that there be an interpretation of the words "more votes are cast" in Article 177, 2B of the Constitution of Guyana. Now, in the affidavit in support, which is at page 98 of the bundle, our client deposes to the fact that at paragraph 22, that in accordance with the order, that is the gazetted order 60 of 20, and amended as at the 29th of May, and pursuant to section 96 of the RPA, which Your Honor, Justice Witt has pointed to, the Chief Elections Officer is required to determine the total number of valid votes. And in accordance with Article 177 2B, the deponent says that of the Constitution, where there is the reference to more votes cast, it must necessarily mean more valid votes cast. Now, we came to court, Your Honors, because on the 16th day of June 2020, the chairman of GCOM wrote to the Chief Elections Officer requiring that the Chief Elections Officer submit to GCOM a report as required in purported compliance with section 96 of the RPA and Article 177 2B of the Constitution, using the results of the recount for consideration by the Commission. Now, that is what our client says at paragraph 29 of the affidavit, which you find at page 100 of the electronic bundle. And at paragraph 31, she deposes to the fact that she's advised by counsel, and she verily believes that the expression "more votes cast" in 177.2 has to be construed in the light of Order 60 of 2020 and the amending order.
So, Jeremy, is that, I'm trying to wrap my head around that suggestion that an article of the Constitution of Guyana can be either influenced by or dependent on a piece of subsidiary legislation passed many years after the Constitution came into effect. Does that sound right to you?
No, well, my lord, the point is that in the Constitution itself, there is a reference in section 162 to if I can just read from 162. The Elections Commission shall have such functions connected with it or related to the registration of electors or the conduct of elections as are conferred upon it by or under this Constitution, or subject thereto any act of Parliament, and subject to the provisions of this Constitution, the Commission shall do a number of things. Now, in respect of all of those matters, the functions of the Constitution, the functions of GCOM are directed by legislation. So the Constitution itself says that GCOM's functions under this Constitution are subject to any act of Parliament and subject to the provisions of the Constitution itself. Now, 177(2). Your Honor is hearing me?
We're hearing you.
Okay. 177(2) provides that the presidential candidate shall be deemed to be elected as president and shall be so declared by the chairman of the Elections Commission, acting only in accordance with the advice of the Chief Elections Officer, after such advice has been tendered to the Elections Commission at a duly summoned meeting. Now, our point is not that the Court of Appeal was interpreting the order. Our point is that the Court of Appeal was interpreting the Constitution in the light of GCOM's special powers exercised under Section 22 of the election law. And Section 22 of the election law empowered GCOM to do these things. Your Lordships, do you have the election law in front of you?
What page of the record is it?
It's not in the record.
Well, then I wouldn't have ready access to it. But if you indicate what section you are referring to, then certainly I will have a look at it after.
Okay, it is Section 22 of the election law, and it provides GCOM with certain powers for the removal of difficulties. Section 22(1) says, if any difficulty arises in connection with the application of this Act, the Representation of the People Act, or the National Registration Act, or any relevant subsidiary legislation, the Commission shall, by order, make any provision, including the amendment of the said legislation, which is why I was interested to hear Mr. Mendez submit that GCOM was an executive body. It clearly is not an executive body alone. GCOM has power by order to make any provision, including the amendment of the said legislation, that appears to the Commission to be necessary or expedient for removing the difficulty. And any such order may modify any of the said legislation in respect of any particular matter or occasion, so far as may appear to the Commission to be necessary or expedient for removing the difficulty. My Lord, it is our submission that difficulties arose, that GCOM acted, and that the Constitution fell. Their actions brought into stark relief what exactly was meant by these words, benign as they are. In the Constitution, more votes are cast. And if one of the reliefs which we
Mr. Jeremy, may I interrupt you, please? The Indian Constitution is what you have just described?
I'm sorry, my Lord. I did not hear the question.
under section 177(4), are you saying that the interpretation of the Constitution the appeal undertook is what you have just described?
My Lord, are you asking me whether again, there's a difficulty in terms of me hearing your Honor, which is persistent. And I'm going to ask you, Your Honor, if this is what the question is. Is it that Your Honor is asking me whether I have just described the powers of the Court of Appeal under 177(4)?
No. I'm asking whether what you described was the exercise of interpretation of the Constitution that the Court of Appeal was permitted to undertake.
Thank you. I did get the question this time, Your Honor. Yes, the answer to that is yes, Your Honor. I am saying that the Court of Appeal was permitted to undertake an examination of what was meant in the Constitution by the words, more votes are cast. That question was put before the Court of Appeal in my notice of motion at B. So if you forget all of the things that Mr. Mendez mentioned, except B, I say to your honors that if I moved the Court of Appeal in respect of one matter that fell within their jurisdiction under section 177(4), and they acted in respect of that one matter that they've exercised their jurisdiction under section 177(4). Now, Your Honors, not one of the cases cited by the appellant and the forces arrayed with him, the 9 other respondents and the other party, contradicts the principle of constitutional interpretation regarding the powers given to determine a matter, powers given to a superior court to determine a matter germane to an election, and the finality and exclusivity of those powers. Now, the cases relied on by my learned friends all speak to arbitration, the exercise of powers in respect of arbitration matters. But the question is whether the first question is, does the Court of Appeal have jurisdiction to entertain the motion filed by Esther Davis? And my answer to that is yes. We move the court. At B, in her motion, she asked the court to interpret the Constitution insofar as an election is concerned. And the word election has the meaning ascribed to it in the Narayan case, which I have cited to your lordship. Now, the second question that your lordship's pose was, if the Court of Appeal lacked jurisdiction, what is the consequence in respect of this proposed appeal? Well, my lord, there is a long and unchallenged line of authority which tells us what the answer to that question is. Now, if you look at the case of Rakal, which is at 3313 of the electronic bundle, Lord Diplock at letter E may I continue, Your Honor?
Yes.
Says this: there is thus no room for the inference that Parliament did not intend the High Court or the judge of the High Court acting in his judicial capacity to be entitled and indeed required to construe the words of the statute by which the question submitted to his decision was defined. There is simply no room for error going to his jurisdiction. No room for error going to his jurisdiction. Nor, as is conceded by counsel for the respondent, is there any room for judicial review. Now, in Seniaki, which is at 3236 of the electronic bundle.
3336, did you say?
3266. No, 3276, Your Honor.
3276, yes.
The court, citing the Silver and the Attorney General, says that the question is whether it was ever the intention of creating a tribunal with the ordinary incident of an appeal. Now, in this case, of course, they say to the Crown. That would be to the CCJ. Now, that case is old. It's 1954. But it was repeated, the principle is repeated in the 2011 Privy Council case of Danny Silva Marie versus the Electoral Commission. And that case is at 3228 of the electronic bundle. I'm sorry, 32. Page, and I'm carrying your lordship to page 3244. May I proceed, Your Honor?
Yes, yes.
Now, speaking of Seniaki, which is, as I say, decided in 1954, before Annis Minnick, I point that out to Your Honor. The court says a similar result was reached in Seniaki versus Navarrete, 1954, where it was held that the finality clause applied even to jurisdictional challenges. Then the court goes on, both Strickland, which we referred to, and Seniaki were distinguished in Devon near, but no doubt was expressed on the underlying approach. Now, the court says the underlying reason for this line of decisions was, as the authorities show, the recognition of the necessity for a speedy determination of an election issue. Now, none of the cases cited by my learned friends contradicts that, and Mr. Mendez spent 95% of his time on the merits, but none on the question posed by your lordship with respect well, very little on the question posed by your lordships in this bench query. If the Court of Appeal lacks jurisdiction, what is the consequence in respect of this proposed appeal? And I say in direct answer to that, Your Honors, that the Court of Appeal, the Caribbean Court of Justice has no jurisdiction in respect of this matter. And that is settled, that is well settled in respect of the interpretation of both the finality and the exclusive jurisdiction clauses, especially in the Supreme Law clause. Lord, my learned friends, in asking for special leave, do not carry you to the provisions of the Caribbean Court of Justice Act, which your lordship asked, your honors asked at the end of his 40 minutes to be carried to his 50 minutes, sorry. Now, if you look at section 4 of the laws of Guyana, which conferred the jurisdiction of the court. This is the Caribbean Court of Justice Act, Chapter 307. Section 4, subsection 3 says, nothing in this act shall confer jurisdiction on the court to hear matters in relation to any decision of the Court of Appeal, which at the time of entry into force of this act was, and then there's this word, declared to be final by any law. Now, Lordship, you are being asked for the first time, as I am asking you, to defy the terms, the express terms of the Guyanese laws and the agreement of the CCJ agreement. In the case of Elroy Garraway versus Ronald Williams, that's at 3279 of the electronic bundle. And at 3290, your honors expressed yourselves in respect of a matter which did not concern the interpretation of the Supreme Law, the Supreme Law, and an ouster of its jurisdiction by the Constitution itself of a state. Your Honor said at paragraph 26, as regards the court's ability to overrule decisions of previous final courts of appeal, this court has held in AG versus Joseph and Boyce that it has that power. Further, there can be no appeal from a decision of a final court of appeal to this court. And then your lordships, your honors, usefully refer to the very section 4.3 of the Caribbean Court of Justice Act of 2004. Now, your honors, that point is to be found in our submissions at 44 and 45, paragraphs 44 and 45, page 2963 of the electronic bundle. Now, I'd like to carry you to Patrick Hill and Surgical Life which is a very recent decision of your honors, and I'm looking at page 74 of the electronic bundle, in which at paragraph 11, I can't, of course, do more than what I'm doing now, given the time that I have. Your honors express yourself in respect of section 4.3 as follows. It follows that section 4.3 excludes from the appellate jurisdiction in section 4.1b as Court of Appeal decisions declared to be final by any law at the time of entry into force of the CCJ Act on 8 April 2005. Of course, in Guyana, the Act had been promulgated in 2004. Court of Appeal decisions declared final by section 39 of a statute as amended by section 63 of the Supreme Court of Justice Act. And Your Honor closed by saying, it is therefore declared that the CCJ has no jurisdiction to hear any appeal by Mr. Hill from the Court of Appeal's judgment allowing Sagico's appeal from the judgment of the Severance Payments Tribunal. So, my Lord, it follows that section 4.3 excludes in Guyana the jurisdiction of the court in respect of this matter for the reasons which are set out in section 4.3.
Mr. Jeremy, I just wanted to be clear about something. You see, this submission of yours is applicable whether or not this court took the view that the Court of Appeal itself lacked jurisdiction, or is it that the submission is premised on the Court of Appeal having properly been seized with jurisdiction?
No, my Lord. I've answered the question that the Court of Appeal, I say the Court of Appeal had jurisdiction, but even if I am wrong, I say that this court lacks the jurisdiction to entertain this appeal because the clear and necessary intent of the Constitution and the agreement is that disputes of this type end in the Court of Appeal, even if the Court of Appeal was wrong on the question of jurisdiction.
Mr. Jeremy, so do I understand that, and this is hypothetical, but I need an answer to get an idea of your thinking. Let's say that the Court of Appeal had said that we interpret this phrase in the sense that only if the candidate gets more invalid votes than the other, which would, of course, be quite absurd. But suppose they had said that. So then it is your opinion that, well, it may be absurd, it may be crazy, but that's what they said, so it's final. I just need to know where, if there are some limits, at least in your thinking or not.
My Lord, in respect of the sovereign pronouncement by the Guyanese Parliament in enacting the CCJ Act, and in respect of the provisions of the Constitution, I say with regret that on the authorities, as silly as that proposition is, and of course we are not dealing with that in this case, that's a hypothetical. What the Court of Appeal has said, as your Lordship has quite correctly put it, is that more votes means more valid votes. That's all that they have said. Now, if they had said that more votes means invalid votes, this court has no jurisdiction to trespass on that once it is the provisions of section 4.3 are there, and once the provision is cast in the terms of the constitutional provisions, that this one is.
Let's take it a step further, because like Justice Witt, it's important to try to see what the parameters are with which we are dealing. You can have a situation where the application which is made to the Court of Appeal on its face falls under 177.4, but the response that the Court of Appeal gives to it is one which someone else takes the view, this court takes the view, did not fall under 177.4. Or you can have a situation where the application which is made to it is made purportedly under 177.4, but does not really fall under 177.4 on its face. Are you also saying that the Court of Appeal has the competence to deal with that application, and this court, any other court, is stuck with whatever response the Court of Appeal gave?
Your Honors, that is the result which deeming provision, such as the one which is contained in the Guyanese Constitution with respect to exclusivity and finality, and the conjoined effect of the CCJ Act at Section 4, that is the conclusion that we are drawn to. And it is, I pointed out that as it is a position which has never, Your Lordship asked a question earlier about me asking the court to find for the first time. But it is a position which is well settled by authority and which has never been the subject of rebuke in analogous circumstances. Lee versus Asher, which Mulin's friends cite as authority for the proposition that there is some jurisdiction in an appellate court to reverse a superior court. You're not dealing with an inferior tribunal here, the severance benefits tribunal. We're dealing with a superior court. Lee versus Asher, the clause in Lee versus Asher spoke to, there were two exceptions to the principle of finality in that case. And Lord Mance expressly says in the paragraph before the one conveniently cited by my learned friend, Mr. Mendez, that the first question that he has to determine is the question of jurisdiction. And unless you fell within those two exceptions, you were out. And
I want to pursue this a little further, Mr. Jeremy, because I think this is really the nub of this case. Well, it is an important issue in the case. If a matter which properly falls under Section 163, which therefore is capable of being appealed right up to this court, if such a matter were to be improperly brought before the Court of Appeal purportedly under Article 177(4), then if your view that you take is correct, then you see nothing wrong with the Court of Appeal then usurping what the Constitution says falls under the exclusive jurisdiction of the High Court and itself ruling on that matter, and then there's nothing anybody can do about it.
My lord, I'd like to carry you back to just two cases to illustrate the strength of this point, because it's an important point. I don't think it forms the nub of, I don't agree with you, Lord, Your Honor, that it forms the nub of this case, because I do not agree that the Court of Appeal did as you hypothesized. But if you look at
Mr. Jeremy, it will help me if you were to answer the question in principle and then take us to the cases. Could you help me, please?
Okay. In principle, Your Honor, the court has no jurisdiction to decide whether, upon the material which is placed before it, another superior court granted exclusive and final jurisdiction in a matter. This court has no jurisdiction to determine whether that superior court was wrong. And the authority for that proposition is to be found in the cases of Re-Racal, which is at page 3313 of the record.
Yes, you're taking us to it before by Lord Diplock.
No, well, there's a bit below where we had gone. He said, Lord Diplock continues, my lords, described by Lord J's decision to dismiss the DPP's application as a refusal or renunciation of jurisdiction seems to me to involve a misuse of the word jurisdiction. His jurisdiction was to decide whether, upon the material placed before him, the application should be granted or refused. In deciding that it should be refused, he was exercising his jurisdiction just as much as if he had decided that it should be granted. And I just like to point, Your Lordship, to one other case in the time which I have. It's the Danny Sylvie case at paragraph 50, speaking of Seniaki versus Navarrete, where it was held that the finality clause applied, Your Honors, even to jurisdictional challenges. That's at paragraph 50, and that is a decision of Lord Clark on an appeal from the Supreme Court of Mauritius. And I asked my learned friends to concede that they are asking this court to find for the first time that it has jurisdiction in similar circumstances. My Lord, those are the submissions for the first named response.
Yes. Thank you very much, Mr. Jeremy. We take a break here. It's about almost 11. Now, let me find out, Ms. Kite Thomas. do you propose to make oral submissions? Did you send in any written submissions? You're on mute.
No, please, Your Honors. We do not propose to make oral submissions.
Okay, thank you very much. So we'll take a, thank you. We ask you not to come out of the court to press the red button. Do not. We will reconvene at 11:15.
I think you may turn off your microphones and your video, but do not do anything else.